We start? So, good morning, everybody. My task is to introduce the two final sessions of this very interesting conference. And so we have now starting a session on labor law, trends on labor law in Brazil and Italy, with Professor Monica Sette Lopes. She's on the board there. She'll direct the PowerPoint presentation. And followed by, it was supposed to be here, Riccardo Salomone, but is the co-authors Alberto Mattei, who is a PhD, post-PhD fellow at the Faculty of Law of Trento. So Alberto will follow the presentation of Monica. So Monica, please. I just make one recommendation that we stay in the 20 minutes limit because we're running late a little bit. Sure.
Well, first of all, I would like to thank you all for the opportunity to be here, especially Professor Belantuono, Professor Pupo, Professor Fabiano Lara, and also the opportunity to discuss with Professor Mattei. It's very exciting to have someone to talk about something that worries us a lot, like the situation of the collective bargaining and collective agreement in Brazil and also in Israel. I think Professor Izu too, and I promise to obey the time rules. Well, first of all, just generally speaking, one of my latest worries, something that I have been thinking while researching and writing and doing things to understand what I do. I'm a judge too, so I have to understand and try to bring this experience to a different level, that it's a level of the science, if I should say that, or the theory, if I should say that too. So one of the things I've been thinking since I've been teaching history of law for some years now, is the use of the historiography, of the method of the history to understand the law. Not in the way Savigny did with the historical school. That's something a bit different, because what worries me is not how law goes, how the law goes, how the constitution goes, how the theory goes. It's not only that, but it's the amount of things that we don't know about how law works, because we don't have access to some sources that are in the experience, and even in the experience of the judicial process of a judge when he decides. So that's the point of the starting point. Let's imagine historians 200 years from now trying to discover the ways of the Brazilian labor law. Let's imagine that they were trying to discover what were the trends of the Brazilian collective labor law. What would they see? What documents would? And the impression I have is that if they read only the theory books, they wouldn't see the reality, if there is a reality, of course, but they wouldn't see problems, at least that I see. Some people that work with the unions, lawyers, workers and enterprise people that represent the enterprises in the negotiation. They see things and they live things that are not translated when we do or we write or we research to achieve the theory of law. So that's the point of the starting point. And so we have at one side the historical sources. And now we have something that are the law sources. That's a tradition. You always ask, well, what's the law source of that period? In labor law, what are the law sources? Okay, we have the Constitution, we have the law itself, we have the contract, for sure. But there is this this role played by the collective agreement, that's not very easy to understand, and that brings lots of conflicts of various kinds, not only conflicts on what would be regulated by them, but interpretation conflicts when workers, employees, they want to not to have a right that's set in a collective agreement, or want a right that's set in the law. So we have this conflict that gets us back to the Kelsian pyramid, and it's very difficult sometimes to solve. How to relate them, how to relate historical sources, law sources, how to understand the law sources, if not thinking about the idea of historical sources, the idea of knowing the history that's behind perhaps the existence of collective bargaining, the doing of the collective bargaining, and the existence of the collective agreement. So to show that, I'm going to start with a book, a children's book, that's called Zoom. The author is not Brazilian, and it's a very interesting book because it's a book without words, but the pictures, they show exactly what is the feeling I have about this problem. Here, I don't know if you can see it. Here you have a matter of perspective. First you see this cock, a part of it, then you see a part of him, then you see where it is, then you see where it is from a further perspective, then you see two children, then you see two children inside the house, then you see a house far away, then you see that the house is a piece of the toy of a young girl, then you see that she is playing, then you see that she is playing on a table, then you see that that's just a picture that's in the hand of a boy who is in a ship. Okay, and then you see at the last picture, then you see the planet. Sometimes I think that the theory of law, it's something like that, just that it always starts from this last picture, the planet far away, and I don't know to which degree we get closer to what happens when we have an enforcement problem, when we have a problem, a dispute between employers and employees. So, well, thinking about that, I would think, well, what is history after all? And this is from Paul Vane. He says that it's a palace whose total extension we will never discover because we never know how much is left to historicize. Law is like that. Even if I don't talk exactly about the history of law, I'm talking about something that's always where there's always too much to know, too much unknown, too much to historicize in the sense of getting to know. So we are in a labyrinth. In each field of law, we are in a labyrinth. And we are in this labyrinth also when we talk about collective labor law. In science, law science, and jurisprudence does not give us the keys to the building. So we have to find a way to find these keys, and or at least to know that we don't have them. And that's important to get closer to them, closer to this final point of the picture, the first picture of this child's book. And there it is. There is a picture of my. I love this picture. I use it everywhere. I should stop it, but it's very. It expresses what I want to say. There is my table, my work table at home, in a day of too much work. Like yours? Like yours? Okay, that's my table at home in a day of too much work. Of course, what I want to say with this picture is that inside each of these processes, if proceeding it has a history to tell, and a history that come together with the whole law history, the whole labor law history, the whole collective bargain history. And that sometimes there is no way we could tell it. I'm not talking about a decision, because it's very easy for us to look at a decision and to say, well, here the decision went that way or went that way. What I'm saying is that the conflict itself, it has something to tell us that perhaps it's not relevant for the decision, but tell us something about law, the movement of law, the dynamics of law, something that's not in the books. Somebody said that today here. Something that's not in the books only, but it's in the dynamics of the law. So let's give a zoom, the everyday life. What do the conflicts reveal? How does the everyday life expresses the reality of the relation between law and the reality itself concerning each collective agreement? So for each collective agreement, there is a history, a oral history. Those people sat on a table, they discussed something, they brought to those tables their personality, their interests, if they are good or bad, if I could say so, it's not very correct, but they brought everything, each of those persons were, and they brought out the interest of the category, the workers and the employers, the enterprise, the capitalism, everything is there. And everything is there to be discussed, but in a way that sometimes we don't know how to measure, how to really know. My husband was a lawyer a long time ago, and he came home after those discussions telling what they discussed and how they discussed. And so after that, I look each collective agreement in a different way, because I know there is a whole history behind it. There is always a history of pluralisms. And, well, the interests, they are plural, they are different, they are paradoxal. There is a pluralism in the legal system itself, so that we have to find out which rule we should apply. This may seem very easy, but sometimes when I get a process where I have to decide that, I normally read it and then I leave it a bit there, like we do when we make bread. We do that and then we leave it so that perhaps it could develop the solution by itself. But that doesn't happen. So then I bring it back and I try to solve something that I won't be able to tell all the details because we have a time problem, but perhaps when I write it, I'll give more examples. So the history through the judicial decisions. Well, as I said, it's not only the decision, but the process. Once I had a case, a long time ago, was a discussion between who would be the president of a union. It's something that, well, it has nothing to do with collective bargaining itself. But then I read the names of the people who were there, who want to be secretary and the other positions in that union, and the one who was discussing the situation. And I came to the conclusion that all of them were retired. There is no rule that in the Brazilian legislation that says that a retired worker cannot be leader or official in a union. But that's rather strange. In a very important union, you don't have nobody that is an active employee. So what that means to the Brazilian syndicalism, o sindicalismo brasileiro, what does that mean to the unions in Brazil, to the situation, to the history of that line of representation, workers' representation in Brazil nowadays? For me, it meant a lot. It meant the lack of participation, the difficulties that the unions in Brazil have now, perhaps more than any study, any words, theoretical words that could have been said about that, and there are a lot said about that. The history between relevance and irrelevance in legal epistemology. So this oral history is normally seen as irrelevant to the knowledge of law, but it's not, because there lies perhaps a way to understand the difficulties of enforcement, the difficulties of an absorption, a spontaneous absorption of law, or of what law means. So, collective bargaining, the Brazilian way. So I'm going to make some questions. I won't be able to answer them all, but just to show you some of the problems that we have. So we have in Brazil labor, I don't know, we have labor unions and enterprise unions. So those are the parties in the collective agreement bargaining. So it's called sindicato profissional, that means the sindicato that represent the workers, and sindicato da categoria econômica, that's the union that represents the enterprises. So one labor union per labor category in each city. So that's the first thing. Well, you say that in Brazil prevails the principle of the unicity. I don't know that word. There is one union per seat in each category. For example, people that work in banks. So in Belo Horizonte, you have just one union. Okay? Easy, very easy, but that's not so easy. Why? Because not in the bank, workers in bank category, but in other categories, people can subdivide the category in parts. And by law, we know that we decide which category the worker belongs, to which category he belongs, by looking for the category of the enterprise. So if it's a bank, then we look on the other side to see the union that represents the workers of banks. Okay, this is easy. But for example, if you have a school, then you have various types of schools, language schools, schools different types of schools. So you have to choose, to look for, to see which school that worker works, to find the right agreement that applies to him. But that's not only that. Sometimes this subdivision is so specific, it's so specific that it's very hard to decide which is the right agreement. Okay, does the employee feel himself as a part of the process? The answer would be no. The example of the retired leaders is enough to say that. Since I have 5 minutes, I won't tell more about it. The collective agreement bargaining process. So there in Brazil, it's possible to have an agreement between employer, enterprise, and union. So big enterprise, they can negotiate with the union that represents employees, or between the union that represents enterprise and the union that represents employees. So which one prevails when there is a conflict? Law says that prevails the one between unions. But sometimes, unless the one that was negotiated between union and enterprise has more rights, is better, more benefits. But how can we find that if a collective agreement has, for example, 100? Which is the best? The whole of the agreement, or should we go through each little thing that was ruled, regulated in this agreement. So it's very difficult to decide because you don't have a ready answer. You have to build it with arguments. And sometimes you don't, it's not easy. You don't know, when I say it's not easy, that doesn't mean that I don't decide. I decided normally very fast, but there is a minute there, there is a period of time there when you look at that and say, oh my God, I don't want to decide that. I don't want to have the task to do that. And then you decide. But see, this minute that when you don't know what to do, is very relevant because it shows a difficulty in the system that's not easy to solve. I'm ending. The union that I represent a group of employees. Okay, that's how I have okay, in Brazil, the result of a negotiation applies to every employee. He has no, even if he's not in the union, the effects. He receives the benefits and everything that was regulated there. To what extent can they negotiate? That's another big problem. To what extent can we negotiate? The labor justice is very conservative on what can be negotiated. So if you look, I have time to say that, if you look through the decisions, you'll see that there is lots of agreements, parts of agreements who were declared with no effects because they are beyond that boundary. You say, or they affect something of the interest of the work. Okay, I'm finishing. Okay, and then here, just to start again. Okay, so I think that to know better, to know more about collective bargaining and the unionism, how unions work in Brazil, we should go through details, and we should find historical sources of their work, of the way they work in a detail that's not normally searched, that's not normally part of the law theory, so that we could make a better law, labor law, collective labor law. Thank you very much. Hope I didn't had too much to say. Thank you. I'll try to write it all down.
So, even if I forgot to say that Professor Sete Lopes is a judge and a professor, I think you all have understood that this is part of the talk about the expression of labor law, and you have the understanding and the knowledge of it from both sides.
Yeah.
Thanks. Please. Alberto Mattei. Trends of labor law in Italy.
Good morning, everybody. Thanks, Professor Itz, and thanks for the colleague for this opportunity. So, I would like to present my presentation and discuss with Professor Salomone about the decentralize and re-centralize the trends of the labor law in Italy. Two keywords, no, three keywords, because the aim of my presentation is to show the double dynamics. On the one side, the dynamics of the decentralization, so analyzing the recent dynamics between the regularity source of the Italian labor law directly to deep decentralization. And on the other side, in relation to the opposite dynamics of re-centralization of the dispute and case brought before the European Union Court of Justice. Especially, and this is the three keywords, in light of the recent debate about the Job Act reform during the reform by Governor Renzi. So we have three keywords: decentralize, re-centralize, and Job Acts. And we have multiple actors also: legislator, trade union, and also the judges. And the multiple levels: national, supranational with the European Union, but also local level. multiple actors and the multiple sources and the multiple levels. So the first dynamic is decentralization in the contract and the normative trend. The context of the economic crisis, the Italian trade union law and the collective bargaining are influenced by the current worldwide economic crisis starting in 2008 right now. As regards the two types of system governing them, the sources of the trade union law have traditionally been both legal and contractual since the constitution are into force in Italian starting in 1948 and the part of the trade union, Article 39, was not applied. Second one, the economic crisis caused the breakdown of the unity of action. We called about the Brazilian situation of the unity of action among all the major trade unions, which had been for years at the root of factual trade union system. The so-called Fiat case, and global player Fiat case, is emblematic of that. Requested change in the work condition, and such change were provided for a new collective agreement in 2010 that the major trade union, CGL FIOM, refused to sign. The Fiat case is emblematic of this trend of decentralization and is an example in Brazil, like a whole global player in Belo Horizonte as a group, as a company, Fiat, to produce the car. Article 8, starting 2011, Decree Law number 138, 2011 in August, is a particular type of territorial and firm level collective bargaining, which had and still has the power to derogate from the law and national collective agreements. The legislature in 2011 was convinced that a relaxing inflexible statutory provision through collective bargaining was the means to increase the employment rate. Nowadays, the results deriving from the application of this Article 8 are quite uncertain. Why? And we have to understand the cross-fertilization between the European Union to Italy, the influence from the European Union to Italy starting in March 2011 with the Euro Plus Pact, when there is a decision by European Union for the create more competitiveness. Each country, said the Euro Plus Pact, country will be responsible for the specific policy action it chooses for the foster competitiveness. But the following reforms will be given in particular attention. The first one is respecting national tradition of social dialogue and industrial relation, measures to ensure cost. But the second one is development in line with productivity, such as review the wage of setting arrangements and, where necessary, the degree of centralization in the bargaining process and the indexation mechanism while maintaining the autonomy of the social partners in the collective bargaining process. This is in March 2011. In August 2011, there were a letter directed to Premier Mr. Berlusconi, firmed by Mario Draghi from the central bank, to recommend a reform to Italy. A central bank recommended the reform to Italy in August 2011, and the letter is, there is also need for Italy to further reform the collective wage bargaining system, allowing firm level agreements to tailor wage and working conditions to first specific needs and increasing their relevance with respect to the older layers of negotiation. This is the tendency of the decentralization, and we understand the Article 8 of collective bargaining of proximity if you understand the three levels of collective bargaining. The first one is the intersectoral agreements, which may take the form of a tripartite policy accord or a bipartite agreement between social partners, depending on whether or not the outcome is also signed by the government. This is the typical idea of the consultation of the social partners in the high level. The second one is the sector level collective bargaining. This This was the keystone of the industrial relations system. It aimed to safeguard minimum wage and the range of matters regarding working conditions, such as working time, information rights, and work organization. The third level is the decentralized agreement, but this is the coordination between the first, the second, and the third. The third one is decentralized agreement, may be signed on a company, district or regional basis, and enable to the parties to agree detailed arrangements for such matters as productivity and work organization that reflect the immediate context. In 2011, in August, the new provision of Article 8, the extremely example of decentralization, is a new set of provision. The name of the article is Support for Proximity Collective Bargaining, and was introduced permitting further negotiated derogation both from the provision of sectoral agreement and from certain aspects of the statute law, provided the change accord with the Italian Constitution, EU-level requirements, and international obligation. This new provision call into question the relationship between the national and company bargaining, which now seems to be developing toward a decentralization of the system, strengthened to role to the company or the role of agreement. It questioned for the first time the previous leading role of law and the national collective agreement in regulating labor relation. The regulatory type of intervention, as opposite to auxiliary or promoting support in the article's inscription, gives company and local agreements a power of derogation with a binding effect for all the workers, which national contracts still lack. One of the scholars of Bari University, Vincenzo Barro, said that this is the example of corporatization of the trade union and the collective bargaining with the enterprise. The name is corporatization over than decentralization. It gives effect to company collective agreements on important labor law themes, such as worker main task, for example, flexible contracts, hours, working time, some aspect of employment procedure, employment relation, and also dismissal, as long as the broad economic policy objectives are taken into account and it is decided in accordance with the majority of principle for representativeness. As a consequence, proximity bargaining would be the means to increase employers' power by relaxing flexible statute law on relevant aspects of employment relation for the purpose of increasing the employment rate or merely making employers' organization more efficient. The conceptual layout of decentralized agreement has developed through a specialization of their function in comparison with those carried out by sectoral bargaining, by paying attention to specific workplace features, organizational, technological. These trends lead to company agreements which diversify their areas of intervention compared to those of national collective agreement. In my work for the last 2 years here at the University of Trento, I tried to monitoring the apply of this article and how many articles collective bargaining are here. And in the website Trentino Observatory of Social Rights, I monitoring the evolution is in Italian about the decentralization, and I find on internet and myself the Formanti contrattuale applicativo is the decentralization about collective bargaining of how many Article 8 are signed in Italy, and this website is free to consult, and I monitoring in my project. So I come back for the slide, and I analyze now rapidly the second trend, the recentralization. We have another actor here, the judges, and we have a judicial trend. If we have here European Union source, for example, Directive 99/70 for the fixed term contracts, and in the preamble said, in this case, the definition of fixed-term contract and the relation with not fixed-term contract. For this reason, the parties to this agreement recognize that the contract of an indefinite duration are and will continue to be the general form of employment relationship between employers and workers. They also recognize that the fixed-term and employment contracts respond in certain circumstances to the needs of both employers and workers. Another part of the preamble, part 6, whereas employment contract of an indefinite duration are the general form of employment relationship and contribute to the quality of life of the workers concerned and improve performance. We have also, and I don't read the Article 5 about to prevent the abuse about the use of fixed-term contract in all the member states. And the case of the fixed-term contract in Italy is particular because the Italian legislation on fixed-term work is probably the most frequently amended legislation in the world. Only to mention the reforms which have been implemented since the beginning of the economic crisis, it is possible to enumerate no less than 7 or 8 reforms. Some of the recent legislative developments capable of raising a significant number of fundamental rights challenges with the cross of the national borders. In 2012, with the Monti and Fornero reforms, has introduced the so-called free fixed-term contract. In 2013, the Letta and Giovannini reform last year amended as a change the so-called stop-and-go regulation, that is the period of time which must separate the previous fixed-term contract from the subsequent, with a view to limit the employer attitude to cover stable job position with a series of continuing fixed-term contract. But in this situation, we have a sector, the education sector, and in order to limit the amount of a huge fixed-term litigation in the education sector, where teaching and non-teaching staff are hired on what I would call a permanent fixed-term basis, legislation has been passed providing that all the rules limiting the abuse of the fixed-term contracts, according to the clause 5 of the Directive of 1999, do not apply to the school staff. This creates a problem in front of the judge, because a lot of teacher goes to the judge to change his contract and they change the position. The exclusion of a school staff from fixed-term contract legislation limitation has been challenged by the Italian Constitutional Court in July 2013 in what is to be considered and the true history step. For the first time in its history, the Constitutional Court has referred a preliminary ruling to the European Court of Justice. In fact, in July 2013, it created a dialogue between the Constitutional Court in Italian and European Court of Justice in Luxembourg, and the court in Italian asked to the Luxembourg court if the clause about the measure against the abuse of the 99 directive may be interpreted as precluding the application of a domestic provision which lay down rules on the allocation of the teaching post, goes on to provide that is to be done by allocating annual replacement. Every year there is a new place for the teaching staff, pending the completion of competition procedure for the recruitment of permanent member of the teaching staff, thus permitting fixed-term contracts to be used without a definite period being fixed for completing for the competition. At the end, and I conclude, the current trend of legal policy, the Job Act reform under discussion in the Parliament after the approval in Senate. The Job Act, the aim, is designed to improve the flexibility of the Italy labor market, commonly seen as one of the most uncompetitive in Europe. Two are the principal key objectives of the Job Act. The first one is a reduction of the number of short-term contracts to the aim to simplify, which increased significantly during the last crisis, a simplification of the main rules of the labor code. And the second one is a review of the system of protection of the safeguard. The debate focused on the right of permanent and long-term workers to be rehired if they were dismissed without a justified cause. This was previously covered by the famous Article 18 of the Statuto dei Lavoratori, which is partly replaced by the new law. Article 18 was brought into to protect workers from unfair or contractual dismissal. This system of guarantees was considered one of the main contributors to the rigidity of the Italian labor markets. JobAct's proposal is to set up a system of public compensation in cash or training programs to be granted to our workers in case of dismissal. It's still unclear now. The Article 18 will be changed because now I'm under discussion in the Chamber of Deputies. The restatement of a worker could be applied only in case of discriminatory or disciplinary dismissal. In case where workers are dismissed for economic reason, they will only qualify for a redundancy payment. This is the change from the idea of the property rules directed to liability rules. So I finish my presentation, and I thank you so much for your attention.
Thanks, Dr. Mattei. I've ground now for 5 minutes of debate. If you have any comments, I welcome comments from the audience. If we do not have comments, we can. Any? You may.
I would like just to
Please.
say something.
Please.
Just to say something that. Well, in Brazil, in the years of Fernando Henrique, before Lula, that means the years 90, yeah. They tried. They passed 4 or 5 pieces of legislation that made an effort to change the tradition labor law system that comes from 1943 in order to put like different types of contracts, but they should be negotiated. None of those things had effects. They didn't work. They didn't negotiate. See, so and in Brazil, for example, you cannot change the rules for dismissal and the rules for the contract, the duration of the contract, by collective agreement. That will not work. So they negotiate in a, I think, not in a very broad way. It's the tradition. You don't get to negotiate those kind of things. Okay? Okay, that's just.
Okay, so now we can switch to the 4th and last session of the morning. Using competition and intellectual property law to foster innovation. We have Fabiano Teodoro de Rezende Lara, he's a professor of competition law and IP as well, introducing the welcome to, and then Giuseppe Bellantuono will follow.
Well, first of all, I would like, thanks Professor Umberto Izzo. I would like to start and have a few minutes to thank Giuseppe Bellantuono, which became a good friend, a very nice friend, more than a colleague. I'm really proud of this seminar and for being in this seminar, and I think I can talk in the name of our colleagues, Monica, Felipe, Soraya, Dimitri, Marcelo, that we are amazed of what we saw here. It's easy to understand why Trento is the #1 university in Italy, having all other universities so old, but they have the best staff. And I don't know the other staffs, but I can't imagine that it's possible
You're being too generous,
to have a better staff than this. So I would like to take some minutes to congratulate you and to thank you for having us here. I would like to thank also Pupo and Nazi, who also made an effort to have us here. And on behalf of the Brazilian team that we put together, we hope we can have with this seminar, we hope this seminar is just the beginning of a very fruitful and interesting interinstitutional long-term relationship. And we hope we can briefly have you all over in Brazil to go on with these talks. Well, having that said, my goal here, I'm talking about using competition and intellectual property to foster innovation. My goal here, first of all, I would like to talk about and make some advertisement about my research group. We have a research group in Belo Horizonte, in Minas Gerais, at my university. It's composed by a lot of researchers that work under my supervision, and we are very proud of all that we are producing. And we hope we come to Trento's standard someday. Our goals in this lecture is to provide an overview of the new competition law ruling in Brazil and the panorama of Brazilian laws that are currently protecting intellectual property and innovations. Also, describe some data on the application of the laws protecting competition and protecting intellectual property, and with that, establish foundations for joint research with Italian researchers and the potential uses of competition law and intellectual property law as methods for achieving innovation and, with that, economic and social development. To start, I think we should look at two basic facts. Fact number one, Brazil is a country of recent industrialization. Until 1988, Constitution mostly of the industries in Brazil, and that includes telephony, telecommunications, energy plants, mining, and making steel. This were all state-owned companies. And it meant a big change in 1988 when the Constitution ordered to be sold those companies. So then we started to have a market, and that's a relevant piece of information. There's a second fact that since then, Brazil, in the last 12 years, we multiplied by 5 our GDP and multiplied by 10 in the last 32 years. Actually, and the GDP in 2011 is 10 times bigger than the GDP in 1985, and almost 5 times bigger than 2002. And that's a really big piece of the puzzle. So, comparing GDPs, we can see Italy, we came in 1980, 1986, I think in this point, in 1986, or just before the Constitution, we came to half of Italy's GDP, to slightly bigger than Italy's GDP. Obviously, Italy has 1/3 of the population, so Italy's GDP per capita is, at this time, 3 times the Brazilian GDP per capita, and that's a lot. But this fact, it should mean something when you look at Brazilian institutions, especially industrial institutions. And it implied some need to change institutions and institutional framework, especially regarding marketing institutions and market regulations. We could learn a lot from Italian experience because we are now getting to a size of Italy. not in the GDP per capita, but in production. So it would be very interesting for us to learn with Italian experience. To set some grounds on competition law and competition law authority, we had a law in 1994 when it started, our GDP started growing, and now we have another law in 2011. When we multiplied it by 5, we had to change our law. And we have now a much more complex system and well-structured system. Its structures, now the law, the previous law just stated that it would transform the authority and which was a sector of the Ministry of Justice to authority. And now the new law structures the system. There's some, I should go fast with that because I don't want to take too much time on this, but there were some changes and I'll have to show some data, but the average time of a procedure in 2013, it was 24 days, and it's greatly decreasing the average time of examination of a procedure by the competition authority. It's become more agile over time. The number of cases for joint operations or concentration acts, it diminished by 2013. We have less cases. In the cases judged, we have a smaller proportion of concentration acts and a bigger number of conduct acts, which shows us somehow that CADE, which is our authority, tends to simplify the merger procedures and, on the other hand, to increase attention in the authority for anti-competitive conduct. As this moment, and in the morning I was doing that, I was just checking because we are now participating in another seminar in the end of the month in Stockholm about cartels in public procurements. And that's a big attention with the authority of Brazilian authority at this moment. Well, seeing that, we say, I would go to review the intellectual property laws in Brazil. I have a theoretical part of this study. I'm not sure it should be of some attention. I think it's pretty obvious why intellectual property, innovation, it fosters innovation. Innovation has a long time, long-run effect on the GDP. It establishes the equilibrium of the GDP for each 2 you set up in the innovation. You establish a 4 times higher GDP equilibrium. So if we use the Solow model, we would have a much bigger GDP if we have a lot of innovation and mostly on intellectual property. And if we follow Homer's model, we could see that the sustainable growth is due to increasing rate of intellectual property and innovation. And there's some questions on how to stimulate innovation. It's not a fact that we need competition to have innovation. We could have innovation through public ownership. That's a way. And the Soviet Union did that and sent men to space before capitalist system. So it's a false statement that it cannot be produced in a planned economy system. But we know what happened after, which is it's not sustainable. It doesn't sustain itself. So we have the planning and the state action is a possibility, but not a long-term, and history shows us it's not a long-term possibility or sustainable possibility. On the other hand, private appropriation of investment, we call it in the competitive markets intellectual property. The tension between the problem created with intellectual property is that it creates a monopoly. And this monopoly creates a dead weight, which in essence is the objective of the competition policies, which means competition policies are set up to fight monopoly effects. And intellectual property, it sets up a monopoly. So it would have, or we would find some tension between intellectual property and competition law, but we have, as we see, both are destined or aim the same goal. The exercise of, first of all, to address the tension, we should understand that competitions policies are not an end in itself. And competitions policies are part of economic development or industrial policy. And both avoid dead weight and, well, there's so much to talk about. And actually, on this tension, we should, addressing the tension, try to encourage development. And that's why, or that's the motive for existing competition law. The ultimate and essential foundation for competition is to promote economic development and therefore social development. And competition policies make sense only if aimed at economic development. And in this sense, we can see the jurisprudence and in the way in the US and Europe they change in their economic contexts. And antitrust, Brazilian antitrust policies change in Brazilian different economic contexts. I'm mentioning here, obviously, that there's some cases addressing this. In Europe, the Philips Electronics versus Remington Consumer Products and Lego Juris against the IHMI and Mega Brands case. All these cases, they have a change or they show the understanding of the court, European court, set by European economic context and interest in development. They're not just aiming at competition, but what does it produce? And this tilting in jurisprudence is not, I have now 5 minutes, right? And this tilting in jurisprudence is result of, or echoes the tilting, or the necessary tilting or changes in industrial policy. Competition policy changes depending on economic context. And in addressing intellectual property, they should change too. In Brazilian, we have a prospect on one case was in 2006, the case of aluminum profiles for doors and windows. And there was a theoretical admission of anti-competitive conduct for abuse of intellectual property rights on industrial design. But in this case, they admitted to examine but did not condemn the manufacturer because there was no relevant market issues. On the other hand, in many ways, these competition law and intellectual property law, they should be complementary. There is no conflict, and decisions should not be made taking in consideration the institute itself, but the national development. In conclusion, I could say there should be some grounds of interest in regulations between Brazil and Italy, and the existence and scope of such grounds should be subject to some future common research. I now would show some preliminary data analysis just to show what we came up so far with this examination. The first fact to be analyzed would be that Brazil have a high level of non-resident patent grants when compared to Italy, China, USA, as shown in the graphics. Here we have, in the red, the total, the line up here is the total patents, but the red part of the graph is the foreigners' patent, non-resident patents, and the blue part is the residents' patent. And we could see that Brazil have a pretty much stable line for residents. For instance, something we can imagine that something happened in Italy. I was talking to a professor to find out what was it. But something happened to Italy, because Italy had, in 1982, a same profile of more non-resident than resident. And then something happens here, a magic happens here, institutional change or legal change, or maybe neither, and they change the profile to much more resident patents than foreigners' patents. Something should have happened around 1990s. Just to address how bad is Brazil, there's China profile and there's US profile, not too much foreigners or non-resident patent grants. The same occurs with patent applications, because we would imagine, well, that occurs with the grants, but not with the applications. Well, it happens with the applications too. Brazilians do not apply so much as much as the non-resident. And the same happened in Italy. Something happened around the year 90. The applications were for non-resident, and they changed for resident mostly. Something must have happened in the institutional scenario or in the legal scenario, and that's relevant to study. Again, patent applications in China show no change, and at the US, same thing. Another interesting fact is the Brazil has a low rate of patent granting when considered patent applications for the same year if compared to Italy, China, or USA. It is. I'm not analyzing how much of the patents that go in the procedures in 1 year, how much of it comes out, but it's not the same set, but in the same year, how much patents are applied and how much patents are granted. And I do that because you can't follow, because the timeline for procedures in all the countries are something. And that's the ratio. The ratio of Brazil was high just in 82, and then came down, and now we have a granting of average of 8% over the years. 8% of the patents applied, we approve and granted. Italy was around, or had a low rate, but Italy is the green one. But now Italy, it seems, but it was low here and really low here in the 80s, but something again happens in the 90s, and now it changed. it was around 20, not as low. In Brazil was around 20. No, Brazil was high, and Brazil went down, and Italy went up. And it should be, or should have some impacts in GDP and in knowledge production. Again, US and Italy has a much higher rate of approval. US and China are almost an average of 50%. And there's another set of data that is very interesting, that in 2011, and I just found out that China surpassed the US in the patent applications, which means that briefly China will have more patents a year than the US. And that shows me that somehow we will have to discuss what is patent law after all. Preliminary data suggests that there are some institutions and legal rules that should be understood comparatively. And in order to find optimal institutional and legal framework to promote economic and social development. And my best guess is we have a lot to learn from Italy. We have a lot to learn from Italy patent and innovation profile. And the very best guess yet is that I have a lot to understand and to learn from Professor Bellantuono and from Professor Izzo. I thank you very much, and I hope it was nice, the presentation.
Thank you, Fabiano. So I will now leave the ground to Professor Bellantuono for his second intervention, and then we will have probably ground for discussion a little bit.
Thanks a lot, Umberto, and thanks to all the speakers in this conference. I hope that also for the audience it was useful to hear our presentations. And I'm the last speaker, so I will be very, very quick in presenting a few insights about the relationship between law and innovation. And I'm following, of course, the track that was already discussed by Fabiano before me. So, and it is a part of a research activity that we are carrying out here in Trento within the Law and Technology Research Group, which was co-founded by Umberto, by me, by Professor Giovanni Pascuzzi, and Professor Roberto Caso. You can find a lot of materials about and the young scholars working on these topics on our website. So, law and innovation. What is the starting question? What is the most important question for this topic now? It is not whether law can be used to foster innovation. This is a question which is already behind us, because the starting point is that all over the world, many countries, many supranational bodies, many international organizations are have been trying for a while to use law to foster innovation. So the important thing is not just to ask in a theoretical way whether law can be used to foster technological innovation, but how this kind of task should be accomplished. And of course, we can and we shall see that in many cases, the easy path is also a failure. So it is not easy to use law to foster innovation, but it is exactly where comparative law and a comparative approach jumps in and becomes extremely useful, or so I will argue. So here are the main questions, just to start with. To what extent we can engineer this relationship between legal change and technological change? Okay, and it is more or less the kind of relationship that I have in mind when I map the relationship between legal innovation and technological innovation and growth. Of course, I also mention, for the reasons that I'm going to explain in a minute, international trade. Because international trade, of course, integration in international exchange is an important growth factor, but at the same time is tightly connected to institutional factors. So from a comparative point of view, it is extremely important to understand to what extent national law can be used to foster innovation, but at the same time, to what extent national law can be used to foster international trade or to dismantle, to break down barriers to international trade, in itself a factor for growth. Okay, let's go on very quickly. I will now discuss 4 examples. I discuss these examples in international trade law, in competition law, and in intellectual property law, simply because I believe that each of these examples teaches us an interesting lesson. Now, just to give you the broader context, of course, we already know that the European Union is the first trading partner for Brazil. Of course, commercial flows are now symmetric on the 2 sides of the Atlantic Ocean, because, of course, importing from the EU is much more developed than exporting from Brazil. And more or less is the same also for Italy. Of course, there is much more that could be done to increase the appeal of Italian export to the Brazilian markets. Much more could be done, but it is already a good starting point. We already start from an interesting situation. Now, the question is, from this point of view, is everything fine? Is everything okay? Are there any trade barriers? And to what extent we can say that the Brazilian legal system or the Italian legal system or the European legal system foster or hinder innovation? Now, there are many problems indeed. For example, there are disputes before the World Trade Organization between Brazil and the European Union. And the European Union says that under many respects, there are many weaknesses in how the Brazilian legal system, from the European point of view, is organized. So let's go to see in more detail, even though very quickly, what this means, what these supposed trade barriers are, and what they effectively mean, what they do mean. For example, what about disputes before the World Trade Organization? And here we can identify an interesting legal strategy that was pursued by Brazil in the last decades. That is, Brazil built up a kind of legal capacity, investing in legal skills, in building in growing up a group of lawyers, experts in WTO law, a legal capacity to fight other countries before the dispute settlement panel in the WTO and change the interpretation of the WTO rules. So the first lesson that I identify is, and is the description of how Brazil, in developing this legal capacity, at the same time was able to pursue its own industrial policy, its national industrial policy, exploiting the room left in interpreting the WTO agreements. It is exactly this lesson which seems extremely important. That is, when we talk about using law to foster innovation, we have to focus, first of all, on interpretative practices, okay? Because we are working with an incremental change that can be extremely useful even when it is much more difficult to change the black letter rules, the text of the rules. There is always room for interpretation, but we need this kind of legal capacity. We need to build up this kind of legal capacity to change the interpretation of the rules, to pursue a specific goal. For the worse or for the better, of course. We can argue to what extent it is a good idea for Brazil to pursue a specific, or for any other country, to pursue a specific industrial policy, but this is exactly the legal strategy which is interesting for us. Now, let's go to a second example. And I propose this second example because it is a usual receipt which is proposed in international circles, that is, in international debates about how to use intellectual property law, and more specifically patent law, to foster innovation. And one of the suggestions is just choose one model of patent law, avoid fragmentation, avoid using many models of patent law, and for example, for the European Union, it has meant to go toward a unitary patent law and a unified patent court at the European level. And the European Union says, well, there are many advantages that can be obtained, for example, reducing the cost for patenting and increasing the rate of patenting, and in this way, usually you have a assumed close relationship between increasing the rate of patenting and increasing the rate of innovation. Okay. And the costs that can be reduced with a unified patent system are usually the translation costs. So the costs, according to the European Union, go down to a large extent simply because we can choose to adopt a unified patent system and a unified litigation procedure for patents across the European Union. Now, the real world is always messier than we try to organize them with our concepts. And indeed, there is a lot of literature that says that the European unified patent system doesn't work very well or will not work very well. It is still in the implementation phase, but there are many authors that fear that it will not work at all. And this is relevant also for the relationship, of course, between the European Union and, for example, the Mercosur, including Brazil, of course, because it is clear that the EU is a global player, Brazil is a global player, and they are negotiating an important trade agreement. Of course, there is an ongoing negotiation also with the United States, but the question is, what model of intellectual property rights is the European Union trying to shape and try to export in these trade agreements? If there are some problems, even in the European Union, and the unified patent system is not going to work, on which basis can we negotiate with other countries outside the European Union? So there are many reasons why I cannot go into the details of the unified patent system, but there are many authors explaining why it cannot work. For example, because indeed there are 4 different models still coexisting even after this reform, and also because the litigation before the Unified Patent Court could be biased towards some specific interests and against other interests, and this explains also, for example, because why Italy did not subscribe to the regulation for the unified patent system, even though Italy chose to give its adhesion to the Unified Patent Court, probably in an incoherent way because it is not clear what is the innovation policy which is behind these choices. But we have a very messy situation now, but it is clear that the main lesson from my point of view is how to coordinate innovation policies across multiple levels. And it is also an issue that, of course, surfaces in consumer law, but also in many other fields. But it is exactly the problem that should be tackled, should be faced when talking about comparing innovation policies that can be exported or that can be negotiated in trade agreements. Now, just to go quickly to the next example, you probably know that I usually work in the field of energy law, so let me just spend a couple of minutes about an energy law example. And it is an example from Brazilian energy law. And in Brazil, like in Europe, there is a short-term electricity market. But the short-term electricity market in Brazil has a design which is very different from the European short-term markets. Why it is very different? Because it is not really a market. The Brazilian short-term market, the mercado do curto prazo, is not really a market, but this is simply a place where differences between electricity injected and electricity withdrawn are settled. So the generators, the producer of electricity, and you probably know that 80% of the electricity produced in Brazil comes from hydro resources. The producers settle their differences in the short-term market, but exactly because most of the primary resources are hydro, it is production from water, electricity from water, there is a very high risk for the generators to use the short-term market, because the price to settle the differences is very high. It could be very high when, for example, there is a water deficit, when, for example, there is a drought, like, for example, in the last few months in Brazil. So generators do not enjoy any flexibility in using this short-term market, which is not really a market, but they face a very high risk, and they cannot choose how to change their production plans simply because they are forced to use this short-term market. So what could be a good solution? Switch to a real short-term market in which the match of supply and demand helps the generators to enjoy more flexibility in their production plans. And you could, of course, ask an important question, but is it simply a way to imitate the European solution, that is, to imitate the electricity short-term markets in Europe? Not at all, because it is clear that the structure of the electricity system in Brazil is very different. So the short-term market in Brazil should be a market for the reason that I was explaining a minute ago, but should be a very different type of short-term market, not simply an imitation of European short-term markets. So the lesson in this case is unpack the different components of a policy. There is a general idea for implementing a policy. Use a short-term market because it provides better incentives and greater flexibility to the generators, but at the same time, there are many details that should be taken into account and not simply imitated because they are already implemented, they are already used, even successfully, in other countries. Okay, so let me just go to the last example, again, an example that I draw from a Brazilian competition law case, and also Fabiano already talked about the abuse, the possible abuse of intellectual property rights, and this is another famous case, still pending, as far as I know, involving the most important car manufacturers in Brazil, and of course also Fiat, and there is a suspect that they are prevented independent producers of car components to develop their own commercial strategies, simply threatening them with legal actions for infringements of intellectual property rights. Okay, so the question in this case, the important legal question in this case, is an abuse of an intellectual property right simply threatening a competitor to sue him for an infringement of that right. And of course, the main argument on behalf of the car manufacturers was we need to enforce our intellectual property rights for the car components simply because we have to invest in innovation. Otherwise, we cannot recover our investments in research and development. But the commissioner in the preliminary investigation in the Brazilian competition law proceedings has already rejected this argument because investments in innovation can already be recovered by the car manufacturers in the primary market for the new cars, for selling the new car, for the sale of the new cars. Okay, so what is the lesson that I think is important in a case like this? We could say, well, the Brazilian legal system using competition law against the holders of intellectual property rights works against innovation. That is, prevents innovation because it weakens intellectual property rights. probably this is not the right way to understand the situation, because we can observe in many other countries or in many other legal systems, in the European one and also in the American one, exactly that kind of reasoning. That is, competition law has to control how intellectual property rights can be used. So the abuse of intellectual property rights should be kept under control by competition law. It is a difficult balance. I don't have time to discuss, for example, to what extent the United States Supreme Court was right in the act of this case in saying that when there is a settlement between competitors, that settlement can be checked under competition law and it can be void because of its anti-competitive efforts, or whether it is right, the European Commission is right in saying that, for example, Motorola cannot sue Apple when there is an infringement of fundamental patent rights that can be used within consortia. Okay, I don't have time to discuss in detail these cases, but the main lesson, in my view, is that only when you have legal decision-making processes open to innovation, that give a priority to the innovation dynamics, you can achieve a good balance between different goals, protecting intellectual property rights on one hand, but at the same time fostering competition. And the idea of the Schumpeterian creative destruction should be exactly this: help support the challengers that innovate and not simply protect the incumbents simply because they invested in the past. Okay, this is the right way probably to understand what is the meaning of the creative destruction in the sense made famous by Joseph Schumpeter, of course. Just to come to a conclusion, these are the 4 lessons that I have identified in these 4 examples, and in my view, they are a good starting point, also tightly connected to the ideas that Fabiano was presenting about analyzing data, quantitative data to begin with, and then focusing on specific case studies, just to understand what is the interplay between legal institutions and innovation. So, just to come to a quick conclusion, there is no reason to assume that the Brazilian legal system or the European legal system or the Italian legal system are automatically more or less friendly toward innovation processes. Because the interplay between the legal context and the innovation process is almost never linear, is almost never so clear-cut. In many cases, innovation is a dynamic process which is non-linear. But it is clear that we have to explore all the connections that link together the different parts of the legal context, just to understand what the impact of the legal context could be on the innovation process. Thank you.
Thank you, Giuseppe. So now we have time for discussion. If there is anyone who wants to raise his hand and comment. Paola, please.
Thank you for your very insightful presentations, both the 2 panels, so all the 4 panelists. I have a question related to the last 2 panelists and the last topic. Then, I think that the core of both your presentation was this balance between innovation and competition. And moving from the cases that Professor Bellantuono showed at the end of the presentation, I was wondering whether you think that this balance between competition and innovation needed different rules or principles, depending on the fact that this balance is drawn at a regional level, so let's say national or even European or Brazilian at the other side, or transnational level. So if we are looking at the relationships between Brazil and Europe and the aim to foster transnational trade, for example, between the two countries. Also there, we need to balance innovation with competition, of course. Do we need different tools to draw this balance when we speak about international trade compared with the tools, the legal tools, I mean, that we need at the European or Brazilian level, or even at Italian or versus Brazilian level? And one of the examples could be, I've heard about in Giuseppe's presentation about abuse. Are there like open-ended terms, general clauses, a good instrument to tackle this challenge at transnational level, or do we need a different approach, like a list of practices, a list of details, rules, few but more details, something like that?
So, for the tools and the interpretation of competition law and the interface, I would look at the data first to know if we need different tools or not. I think for a great period of time, Brazil had tackled very wrongly intellectual property until the end of the last century. The idea was not completely adequate for Brazilian needs of development. And we can see that, well, my preliminary data shows, and I may be wrong, and I may write the exact opposite after that, but if I say this, but China has a very interesting approach on absorbing new technologies, and from absorption, producing new technologies, and now it inverted the applications and grants. So my guess would be that we need to look the data. I know for a fact now that we have a different profile. There was a data I didn't say, but in 2012, you cannot find too much information about a patent in intellectual property in Brazil, about Brazil in Brazil, and that's a problem. And I found most of the data in WIPO, and in the international office. And in Brazil, there was a data here. I guess I can open it. But in 2012, from the top 10 producers of patents, resident producers granted patents, the first one was a conglomerate that produces refrigerators and white produtos de linha branca.
White products.
White products.
White appliance.
Yeah, which is really concentrated in Brazil. The second one was our university, UFMG. The third one, UERJ. The fourth one, Unicamp, federal centers of knowledge. So the profile of who is patenting and what is patenting, I think it should influence the tools we're going to use. It's really different from the profile of Italy's patenting grants, because it's mostly the first one in Italy, I think it's chemical in those industry, and then tires, and then for 2012. So we have really different profiles in technology, and we want to get where you are. And I'm not sure if we use the same tools that you're using, we're going to get there. We have a history in Brazil that we use the tools that Europe was using, and we didn't get too far. That would be my answer to the first one. I'm not sure.
Just just a very short reply. It is clear that the balance will take place in many different arenas at the same time, and we can expect a lot of foreign shopping because it is clear that depending on the profile, for example, if you have a majority of small, medium enterprises or whether you have the big multinationals that have different patenting capacity, the balance will cost less or more for each country or for each economy. So the adaptation to new rules at the international level could be more or less costly. But it is clear that for each country, or better for each region, the European Union and the member states on one end, and Brazil and Latin American countries on the other hand, some kind of adaptation is needed. So it is not conceivable today that only national strategies for innovation policies can be pursued, because international trade is also important, and it is clear that international trade creates a lot of interdependencies. So it is clear that a balance must be found, but the national legal system will be influenced by the balance which is also sought for and achieved in the international arena.
So, anyone else want to comment? Please.
Professor Brantuano, I agree. Legal changes often depend on the type of interpretative practice. In Brazil, there is the different concept of consumer. It's no problem. In Italy, how verify the dialogue between legislation, consumer legislation, the Italian Civil Code, and corporate law and property law? For us, it's a great problem. Mainly, the improvement of consumer code.
Yeah, probably this is a question that Paula can answer better than me. And of course, you have to ask questions also about the previous presentations. But indeed, it is exactly the idea I was trying to present, identifying the interplay among the different components of a legal system or a legal context. And it is clear that, well, to some extent, we could also say that intellectual property law is tightly connected to consumer law. But we could say the same, for example, for products liability. The rules about products liability that in some cases are also included in consumer law. And the question then could be asked, of course, at different levels. We have the rulemaking production, and we have the enforcement process. And it was very interesting in your presentation and the presentation by Paula, just to see how you believe that the effectiveness problem is a real one on both sides of the ocean, even though it could be addressed in different ways. And Paula, at the end of her presentation, was raising the question, what is the level to address the effectiveness problem for consumer law? And I'm going to believe that probably the lower level could be the most interesting one to explore. The level which is closer to the consumer. Of course, we have a lot of consumer law which is now made at a global level, at a regional level, but when we talk about the effectiveness of enforcement tools, well, probably we know much less on what happens on the ground at the lower level, and probably this is the level on which we should invest more. For example, you talked about consumer agencies at state level. How effective are they in Brazil? Which powers of enforcement do they have? And this could be an interesting topic to explore, because it is clear that, of course, we have a lot of policies to increase the effectiveness of enforcement in European consumer law, but as Paula was saying, and probably she has something to add on this, their effectiveness is still doubtful. So this is my point of view. I don't know if it answers your question.
I will just add a few words. Yes, indeed. I mean, the borders between all the fields of law you mentioned are becoming more and more blurred into new modern legislation. So we have a lot of overlap between them, and also a coordination problem in some cases. About what has just been said in terms of enforcement, I would also subscribe Professor Bellantuono's view about the vicinity of the protection, safeguard of consumers, probably with an exception or with a complementary observation regarding the cross-borders cases, of course, on the one side, and the use of electronic means on the other side, of course, because when you start to see a consumer using electronic means, going on the website, purchasing on the web, entering distant contracts, there it's much more difficult to have like this an enforcer which is close to the consumer, of course. In that case, I think that coordination at European level and then maybe also at some point global level is needed. I'm not saying by law that could be an optimum, room for private regulation, for example, but the consumer in many instances needs a response which is not given as close as he is at that point.
Okay, so if there are no other interventors, I may close the session, restating the big thanks to the organizer for organizing such a challenging venue in Trento. From the Brazil point of view, I think it was the starting of something. Something was going on, and probably we should foster venues of research, joint research, maybe grounding this research on empirical grounds, like you pointed very aptly in your presentation. And thanks to Giuseppe Bellantuono and Federico Puppos for organizing the meeting, and I leave the last word, of course, to
just for
Giuseppe.
for the organization. Thanks a lot to all the participants, and we have a lunch, and we hope that you will stay with us also for the lunch. And there is also a workshop after the lunch with some representative from the business world, just to explore also opportunities to come closer. To put closer the university world and the business world, the industry world. Okay, so you are also invited to participate to this workshop if you are interested.